Good morning, everyone. My name is Tamia Scipio Smith. I'm from PCCY, a child advocacy organization working in Montgomery, Bucks, Delaware, Philadelphia counties. We are here because we are celebrating a landmark ruling in the fight for fair funding education for kids in Pennsylvania. For years, schools and parents have been told that the court cannot hear cases relating to how education is funded in Pennsylvania. School districts, parents, and other stakeholders disagreed. They did not believe the legislature had passed laws that ensured that every school district in the state has enough funding for all students to have an opportunity to receive an adequate education, or ensure that every student has the same basic level of educational opportunity to meet academic standards and to obtain an adequate education that prepares students for civil, economic, and social success. A few weeks ago, the Pennsylvania Supreme Court disagreed. The Supreme Court of Pennsylvania ruled that the case can proceed. So today, we celebrate a victory for all children in Pennsylvania who go to school in districts that know that kids need services but don't have the money to provide them. Thanks so much for joining us as we celebrate.
Good morning. My name is John George. I'm the Executive Director of the Montgomery County Intermediate Unit. And today we are truly celebrating a landmark ruling for all the children in the Commonwealth of Pennsylvania, but not just the children in the Commonwealth, but all the children here in Montgomery County as well. This has been a hard-fought victory that has us been making for 26 years. And during that time, for the past 26 years, our school districts have long fought for an equitable and adequate funding system in Pennsylvania. This case has strong implications for school districts such as Norristown and Pottstown and every school district that has been forced to rely on continuously raising property taxes to provide a fair and equitable education system. Currently, Pennsylvania funds school districts at about 37% of what it actually costs to educate children. That means the majority of funding for children comes from local property taxes. At one time, this funding was 50-50, where the state gave 50% of the share and local school districts gave 50% of the share. But over the years, that has eroded, and the state has intentionally shifted state funding onto local property taxes. The result of that system has created an inequitable system. School districts that have more wealth are more likely to have courses such as honors courses and AP courses, chemistry labs, more art programs, better facilities, and are more easily able to attract high-quality teachers. Their counterparts in less wealthy school districts unfortunately cannot do the same. This is not a thorough and efficient way of funding public education. In fact, this is a system that has intentionally created segregation by wealth. It is not equitable, it is not adequate, it is not fair, and it is not right. Now, our Pennsylvania General Assembly can fix this system at any time, but for 26 years they have chosen to ignore it. That tells me they either don't have the ability to do it or they don't have the courage to do it. Therefore, we applaud the Pennsylvania Supreme Court for taking this decision and taking a look at what is right and fair for all children, and for making the decision they did just a few days ago. We look forward to the Commonwealth Court and hearing this case to make sure all children have a fair, equitable, and adequately funded public education system. Thank you.
Good morning. I'm Janet Samuels, Superintendent of the North Area School District here in Great Montgomery County. As Americans, we have a rich history and enjoy some of the greatest opportunities in the world. Economic advancements in our society are clearly shaped by education. Although education is the great equalizer in our society, the Commonwealth of Pennsylvania is one of only 3 states in the country without a basic and a fair funding formula that distributes appropriate and adequate resources fairly and with consistency. Unfortunately, Pennsylvania has one of the widest funding gaps between the wealthiest and the less endowed school districts as compared to any other state in the country. In terms of funding in the North Area School District, for example, 7% of our annual revenue is from the federal government, while 20% of our revenue is from the Commonwealth of Pennsylvania. As a result, a large portion of our resources are based on our local community. This lawsuit has an opportunity to really help to balance where we should be as far as funding education here in the Commonwealth of Pennsylvania. A fair funding formula must be put in place that considers factors such as poverty, English language proficiency, homelessness, foster care placement, etc. All items that we know will greatly affect school districts' budgets. Increases in long-term per pupil funding will lead to increases in educational attainment. Today is an opportunity to really celebrate. It matters not what county or area one resides in. We're all Pennsylvanians. It should be about how we support and do something to balance this unfair burden that's been placed on educational systems in our state. It is clear that if our students are to have opportunities for unparalleled advances in our society, there must be a fair funding formula. This lawsuit, this case matters. Together, let's make a difference for the children in the Commonwealth of Pennsylvania. Thank you.
Hi, my name is Ben Geffen. I'm an attorney at the Public Interest Law Center. We represent the plaintiffs in this case, along with the Education Law Center of Pennsylvania and the law firm of O'Melveny and Myers. It's a big win to get this decision from the Supreme Court of Pennsylvania, and I want to talk just briefly about what will happen next in the litigation. Up to now, there's been a fight over whether the constitutional requirement should be left to the legislature to decide for itself, or whether courts have a role. And now that the court has spoken, it's said that the courts indeed have a role and that the case can go forward in the Commonwealth Court. I want to emphasize that this case isn't asking the court to do something completely novel, completely without precedent. In 28 states where the state constitution has a similar guarantee, courts have allowed lawsuits like this to go forward. This includes every state bordering Pennsylvania. We're not asking Pennsylvania to go out on a limb here. We're asking Pennsylvania to catch up to our neighbors and to the rest of the country. So our job now is to go back into court and to prove at trial that Pennsylvania doesn't provide enough money and doesn't provide it with parity. The court will have to make some decisions, including how much education is necessary. But fortunately, the state has already adopted standards that can help guide that decision, the PSSAs and the Keystone exams. The court will also consider the abundant evidence of inequality in our educational funding system, and it will have to decide how much of that inequality flows from deprivation of funds to poor districts. We're going to put on evidence from many sources, from superintendents, from scholars, from parents, to show that underfunded districts cannot provide the education required by our Constitution. And there's still an enormous need, though. I want to emphasize finally, this is litigation's great, but there's really still an enormous need for legislative advocacy as well. Any relief and any permanent solution is going to have to involve the General Assembly, so it's very important for our elected representatives in Harrisburg to hear how important this issue is for all of Pennsylvania's citizens. Thank you.
Good morning. My name is Michael Huff. I am a resident of Montgomery County and the parent of 3 children who all attend Pennsylvania public schools. I and the other speakers will be reading from the recent Supreme Court decision of William Penn School District et al. Versus Pennsylvania Department of Education et al. Constitutional promises must be kept. Since Marbury versus Madison, it has been well established that the separation of powers in our tripartite system of government typically depends upon judicial review to check acts or omissions by the other branches in derogation of constitutional requirements. That same separation sometimes demands that courts leave matters exclusively to the political branches. Nonetheless, The idea that any legislator can conclusively determine for the people and for the courts that what it enacts in the form of laws or what it authorizes its agents to do is consistent with the fundamental law is in opposition to the theory of our institutions. Thus, we must be skeptical of calls to abstain from a given constitutional dispute. We hold that this is not a case that requires such abstention. Accordingly, we reverse the Commonwealth Court's contrary ruling.
Good morning. I'm Tina Valero, Director of Community and Government Relations for the Montgomery County Intermediate Unit. Petitioners assert that respondents have violated their collective constitutional duty under the Education Clause to provide for the maintenance and support of a thorough and efficient system of public education to serve the needs of the Commonwealth. Petitioners aver that respondents failed to provide the school districts in question with enough funding to ensure that all students have an opportunity to receive an adequate education. Where funding is measured by the allocations suggested by the General Assembly commissioned costing out study, and adequacy is tested by whether the students are prepared to meet state academic standards and to achieve civic, economic, and social success beyond school. Petitioners maintain that the current levels and allocation of school funding are irrational, arbitrary, and not reasonably calculated to ensure that all Pennsylvania school children have access to an adequate education. Consequently, petitioners claim the General Assembly has failed to maintain and support a thorough and efficient system of public education.
Good morning. I am Hakim Jones from Norristown Council, speaking in behalf of council as a whole. I would like to say this is a great step in the right direction for our children of Norristown and surrounding communities that struggle with similar challenges that we do. Petitioners assert that respondents have violated equal protection principles under Article 3, Section 32 of the Pennsylvania Constitution. Education is a fundamental right, triggering strict scrutiny of the disadvantageous classification reflected in the disparity of educational resources at the disposal of low and high wealth districts. Petitioners do not dispute that a constitutional school funding scheme would still enable wealthier districts to provide greater resources to their students than districts that cannot raise as much money through local taxes. But they maintain that the Constitution imposes a duty on the Commonwealth to ensure that all students have the same basic level of educational opportunity, that is, the same fundamental opportunity to meet academic standards and to obtain an adequate education that prepares the student for civil, economic, and social success.
Good morning. My name is Jeff Brody from Montgomery Early Learning Centers. Respondents argue that this court cannot define thoroughness and efficiency while still respecting the legislator's primacy in fashioning educational policy and preserving its ongoing flexibility to refine that policy to adapt to changing times and evolving needs. But centuries of litigation leading to judicially enforceable definitions of such vague terms as probable cause, due process, equal protection, and cruel and unusual punishment undermine the argument. Courts give meaning routinely to all manner of amorphous constitutional concepts, including those that lie at the intersection of legislative prerogative and judicial review. And they do so while still leaving room for future development by whatever government body or mechanism the law fairly prescribes.
I'm Karen Dunlevy, the parent of a 9th grade high schooler, member of Lower Merion Township's Interschool Council, which is the parent organization of our 10 schools. To the extent that our prior cases have suggested, if murkily, that a court cannot devise a judicially discoverable and manageable standard for education cause compliance that does not entail making a policy determination inappropriate for judicial discretion, or that we may only deploy a rubber stamp in a hollow mockery of judicial review, we underscore that we are not bound to follow precedent when it cannot bear scrutiny, either on its own terms or in light of subsequent developments.
Good morning. My name is Kathy Badowski, member of the Colonial School District Board of Directors. 2 decades after Marbury, in another paean to the importance of judicial review, Chief Justice Marshall cautioned that the judiciary cannot, as the legislature may, avoid a measure because it approaches the confines of the Constitution. We cannot pass it by because it is doubtful. With whatever doubts, with whatever difficulties, a case may be attended, we must decide it if it be brought before us. The spirit of Chief Justice Marshall's cautionary refrain has informed the clear majority of state courts that have held it their judicial duty to construe interpretation, begging state education clauses like ours ensure legislative compliance with their constitutional mandates, no matter the difficulties invited or in many cases confronted. We hold that our education clause, viewed in the overarching context of our cases taking up the question of abstention from political questions, compels the same result. To the extent our prior cases suggest a contrary result, they must yield.
Good morning, I'm Bill Schaffler and I'm with Public Citizens for Children and Youth. To be sure, courts must take great care in wading deeply into questions of social and economic policy, which we have long recognized as fitting poorly with the judiciary's institutional competencies. However, the judiciary has a correlative and equally important obligation to fulfill its interpretive function. It is a mistake to conflate legislative policy making pursuant to a constitutional mandate with constitutional interpretation of that mandate and the minimum that it requires. It is fair neither to the Commonwealth nor to the General Assembly itself to expect that body to police its own fulfillment of its constitutional mandate.
Good morning to every citizen of this Commonwealth. We cannot avoid our responsibility. My name is Ronnie Williams, by the way. I'm School Board Director from Pottstown School District. We cannot avoid our responsibility to monitor the General Assembly's efforts in service of its mandate and to measure those effects against the constitutional imperative, ensuring that non-constitutional considerations never prevail over that mandate. It remains for petitioners to substantiate and elucidate the classification at issue and to establish the nature of the right to education, if any, to determine what standard of review the lower court must employ to evaluate their challenge, but petitioners are entitled to the opportunity to do so.
I'm Jean Sorg. I am the mayor of the great borough of Ambler.
Could anyone else want to, all the other members that didn't speak or do that service come to the microphone and just state your name and where you work and see how you sure.
I'm Jack Hurd. I'm the Human Resources Director of the Montgomery County Intermediate Unit.
Good morning, I'm Ann Rorick. I'm the Chief Financial Officer at the Norristown Area School District, and we are so pleased in celebrating this decision and look forward to a successful court ruling.
Good morning, I'm Brad Landis, Assistant Executive Director at Montgomery County Intermediate Unit. I'm glad to hear this ruling.
I'm Shirley Howe from Public Citizens for Children and Youth. I'm also the parent of 3 children in public schools in Montgomery County. So it's important to me. It's also important to the children throughout the Commonwealth. I appreciate the time of our local elected officials, those on school boards, council, also our superintendent, and the many, many administrators, including Dr. John George, the executive director of MCIU, for coming out, donating your time, or giving your time to this worthy cause. We'll fight, we'll continue to fight, not just in the courts, but legislatively, and we're hopeful and we'll remain vigilant. So thanks so much for your time today. Thank you.